Hey guys, welcome to this video. My name is John Watts, and we're going to talk about a very interesting recent case involving Midland Credit Management. And there's a related company called Midland Funding. And at least in Alabama, Midland Funding files sometimes hundreds of cases a week just in Alabama. And this is a very common situation. And let me sort of set the stage. Midland sues somebody. They then settle by paying money to Midland. And then afterwards, they check their credit reports and it shows that they still owe a balance, even though truthfully they do not owe a balance because they settled it. So this consumer sues under the FDCPA, Fair Debt Collection Practices Act. And you'll see all the attacks that Midland makes. And this is very, very common. Even against experienced attorneys, Midland will do this. But particularly against attorneys that have not filed a lot of Fair Debt Collection Practices Act or Fair Credit Reporting Act cases, this will be made. If you bring a case on your own, which I don't advise, really no reason to, because your lawyer will be paid out of the settlement, and there's what we call fee shifting. But in any event, if you bring a case on your own, you definitely have to expect these types of attacks. So let's take a look at this. I think the judge does a great job of analyzing and then rejecting Midland's arguments. So the technical aspect here is Midland has moved to dismiss the second amended complaint. So you have the original complaint and then the first amended complaint and second amended complaint. So the plaintiff here has been modifying his complaint, which they have the right to do. And so that's what is being attacked here. And so here are the very simple facts. So this Escobar has a credit card debt. Midland is a debt collector. And then Midland reported the debt to the credit bureaus. And that was in an attempt to collect the debt. Now, you'll see Midland will say, well, when we credit report, we're not trying to collect a debt. It's like, well, why else would you report it? That's exactly why you're reporting it. And so their efforts failed. And then it goes to London and London, which I believe is a law firm, collection law firm. So they file suit against him. And then here we have this August 21st check. He paid and settled the debt. Now, he has an understanding of what that means. And his understanding is once I pay it, my credit report will not show anything as due. And if I had known you were still going to have it show up on my credit report as being owed, I would not have paid it or I would have negotiated better terms. Now, we'll see that that gets rejected because there's really no basis for that argument. So here are the facts. Remember that August 21, he pays it. So then August 10, so 2.5 months later, well, I guess it'd be a month and a half later, he reviews his trade line for the paid debt. And he says, well, look, I noticed that it's not showing as being paid. And then he says, look, Midland has voluntarily reported this debt, and that'll be significant later on. And he says, in the alternative, they failed to mark the debt as paid after receiving payment. And he says, this caused injury to my reputation. And then he says, mental anguish. And he says, look, this violated the FDCPA. So what does he say it violated? Well, here's the first section that he says it violated. Is Section E, 1692E. So if you'll remember from our video on 1692E, we actually have two videos. That is on misrepresentations, deception, and E is the general section that just says don't use any deception in collecting a debt. E2 is the character or nature, legal status, amount. That's incorrect. E8 is the false credit reporting or not marking it as disputed. And then E10 is very similar to just the regular Section E. It's just, again, using deceptive means to collect. And so his argument, which is not very good here, but we'll see what does gain some traction here, is he says this London and London violated Section E by allowing Escobar to believe his payment would be accurately reflected. And then he also says that Section F, and Section F is don't do anything that's unfair or unconscionable, by allowing credit to be harmed even after he made payment and even though he understood credit report would not show a balance owing. And so he wants statutory damages that can be up to $1,000. He wants actual damages, costs, and attorney's fees. So here's the legal standard. This is a motion to dismiss under 12b-6. And we've talked about this in other videos. This is where the complaint itself is being attacked. So no depositions have been taken, no interrogatories, those are written questions, have been answered, no documents have been produced by Midland. And so this is just Midland saying, look, take everything as being true in the complaint. There's no way he can win. That's what they're arguing here. And the judge says, well, given that standard, I have to draw all reasonable inferences in favor of the plaintiff. You're attacking the plaintiff's lawsuit, so I'm going to give him every benefit of the doubt. Well, what's the test? Sufficient factual matter that's accepted as true, which is what the judge is supposed to do absent unusual circumstances, to state a claim to relief that is plausible on its face. Well, what does that mean? A claim has facial just means on the surface, just looking at facial plausibility when the plaintiff pleads factual content that allows the court to draw the reasonable inference that the defendant is liable for the misconduct alleged. And then the court does not have to accept legal conclusion. So a legal conclusion might be the defendant was reckless. Well, you might say that, but you want some facts with it. And threadbare recitals of the elements of cause of action supported by mere conclusory statements do not suffice. So if you just say, here are the three elements and they violated all three, without any facts, that's going to be a problem. So there are three attacks that Midland makes, and it's important to understand what these attacks are. So first, they say he lacks Article 3 standing because he has not suffered an injury in fact. And I've kind of hinted at this in some other videos. This is what is often called the Spokeo Challenge, S-P-O-K-E-O. Comes from a U.S. Supreme Court case. And it basically says you've not alleged enough to open the doors of the federal courthouse. You haven't been actually harmed enough to set foot in the federal court. So that's the first argument. Second is you have failed to state a claim for the FDCPA. And there's multiple parts of that. And then third, it's your testimony or your allegations, because there's no testimony yet, your allegations about actual damages are just mere conclusions, and so you don't get any actual damages. So the court's going to address these one by one. So here's the deal with standing. Standing comes from a basic idea that federal courts are there to resolve actual controversies, not to render advisory opinions. So you can't go to a federal court and say, well, if Midland did X, Y, and Z, would you say that that's wrong? The court's going to say, no, I don't give you opinions and advice in the future. Bring me an actual case where Midland did X, Y, and Z, and then I'll tell you if it violates the law. And so this is a fundamental principle of federal courts. So jurisdiction, let me just get this. Federal courts under Article 3 is limited to cases or controversies. And so this is a concept called standing. Now, sometimes this word is used interchangeably, at least by some courts, with something called the real party in interest. And for example, the Alabama Supreme Court has acknowledged that lots of cases sort of mix these terms up. So if you're thinking in terms of a debt buyer, somebody claims to buy a debt, has sued me, sometimes people will say, well, attack them on standing. And that's okay to say it that way. Technically, that's not the right way to say it, but so many courts have accepted that and used that language that, we'll use that also. And what we really mean is the party suing, so Midland Funding or Portfolio Recovery, whichever debt buyer you're talking about, they don't actually own the debt. So they have no basis to sue me. So they're not the real party in interest. In other words, the real party that has the right to bring the case would be Synchrony Bank or Chase or Capital One or whoever it might be. So you could think about it in a car wreck case. If, let's say, you're hit going through a green light, somebody runs a red light, hits you, and then I file suit, not as your lawyer, but I file suit just in my name, John Watts. And I say, well, look, the defendant ran the red light, clearly negligent, actually reckless because he was drunk. Well, the court's going to go, yeah, but it wasn't you, John. I go, well, that's okay. I can still bring the suit. They go, no. It has to be the party actually hurt. Now, in personal injury, we don't sell claims or causes of action. But in a debt buyer context, you can buy and sell debt. So that's really the real party in interest. Standing is just to make the doors of the courthouse open. So let's see what that means. So 3 things here. Injury and fact. And then number 2, a causal connection between your injury and whatever you say they did wrong. And then number 3, the ability for the court to redress or make right what has happened. So you could think of number 3 as, well, it gets a little bit complicated, but maybe there's nothing a court can do, okay? And, I mean, this may be a terrible example, but, there's some 200-year-old tree in your backyard and somebody cuts it down and you sue to have the court tell them not to cut it down. It's like, well, it's already been cut down. Now, you could sue for damages, but it has to be something the court can do. Midland, as most of these companies do in federal court cases, they really attack the injury and fact element. So they don't argue about number 2, which is the causal connection, or number 3, the injury can be redressed. Because here the person's seeking money damages. Well, that's always going to be valid. And the causal connection is you did something bad and that hurt me. And so they're not arguing that understanding here. So they say you haven't suffered an injury in fact. So what does injury in fact mean? So we've got, it's a legally protected interest that's been invaded, and it's concrete and particularized, and it's actual or imminent, not just, you got to love these fancy words, conjectural or hypothetical. So it's not just, well, I imagine something could happen. No, it has to be actual or it's about to happen. And this first part, concrete and particular, which just means it affects you as the plaintiff, not just the whole world, okay? So the party invoking, and that's important, the party invoking federal jurisdiction bears the burden of establishing this element. And remember, this person filed suit in federal court. I'm going to talk about this as I do in a lot of videos. We typically do not file the case in federal court for this very reason, because I know they're going to make these attacks. Even though they're silly, it just burns up a lot of time. It delays the case. And so we file cases in state court, let them remove it to federal court. Well, then who is invoking the jurisdiction? It's not us. And if then they attack us and say, well, John Watts doesn't have standing here, we go, okay, let's go back to state court, which they just have a come apart when you say that. And they go, okay, we'll stay in federal court. They do not want to be in state court. And the reason is, if the case goes badly for them and they get popped with a $500,000 verdict, they'll be subject to just terrible criticism for allowing the case to stay in state court. People will go, well, if we had been defending that debt collector, we would have taken it to federal court. So they just can't bear the thought of leaving it in state court, at least in my experience. Okay, so let's go back to this. And it says at the pleading stage, because remember, no depositions, no discovery, which is written interrogatories, request for production, deposition. The pleading stage is just like you're just starting the lawsuit. General factual allegations of injury may suffice. And Midland says, just kind of tracking these words here, you haven't met this because there's no injury in fact. And they say, well, look, first of all, there's no concrete injury. And they cite to the Spokio case that we've referred to. And in Spokio, the court reversed the Ninth Circuit's appellate court on the West Coast for failing to address whether procedural violations of the FCRA were sufficiently concrete to confer standing. And then the court said, well, let us explain what concreteness means. And they say here, a bare procedural violation divorced from any concrete harm does not confer Article 3 standing. But then it also says that the risk of real harm can satisfy this. So they give some guidance, but they don't lay out just here's absolutely 100%, the roadmap to tell you what to do. And they say plaintiff need not allege any additional harm beyond the one Congress has identified. So if Congress identified harm that comes from a federal statute being violated, then that should be sufficient. Now, that doesn't stop these guys from attacking the standing of the lawsuit. And keep this in mind. If they beat you on standing and you filed in federal court, your whole case goes away. Now, you could refile it, but maybe a statute of limitations has expired now. So again, that's why we tend to file these in state court and then let them be removed to federal court, or we stay in state court, which we're perfectly content to do that. Okay, so Supreme Court left open the question of whether the particular procedural violations, in this case it was the FCRA, alleged in the case entail a degree of risk sufficient to meet the concreteness requirement. And then it says, but look, it might be that there's some procedural requirement that is violated that results in no harm, and that not all inaccuracies cause harm or present material risk of harm. And they start kind of offering opinions about what this might be. Is it a misspelling of your name, or, what might not be good enough to get you in federal court. And really, that's called dicta. That's not the actual holding of the case. That's just the court kind of going off on a tangent. And so they're not bound by that. And we see them, they often say stuff that's just doesn't hold up. And later on they go, oh, well, that was just dicta. We were just kind of, talking off top of our head there. All right, so let's try to make this more practical here. So the court's going to say, well, look at the Second Circuit. And here's the quote. We understand Spokio, that Supreme Court case, to instruct that an alleged procedural violation can by itself manifest concrete injury. Where? Where Congress conferred the procedural right to protect a plaintiff's concrete interest and where the procedural violation presents a risk of real harm. Okay, so, you may be listening to this, looking at these words going, this sounds like kind of a bunch of gobbledygook. And in a way it is, but just understand this is an argument that's just routinely made. No matter what you do, you bring a case under Fair Credit Reporting Act, Fair Debt Collection Practices Act, the TCPA for robo-dialers blowing up your cell phone, whatever it is, the other side will attack and say, you have no right to be in federal court. So that's why this is significant, why I'm taking some time going through here. So Midland says it's just a bare procedural violation. And the court says, no, I don't agree. First of all, say the FDCPA creates a substantive, not merely procedural right, the violation of which itself give rise to a concrete injury. So they cite this case from Eastern District of New York. And then second, they say even if you look at their rights as just procedural, so in other words, it's not substantive, it's just, court or the Congress says you must do this or that. And it's just some procedural right that has no substantive merit to it. Like, you must send a copy of a certain piece of paper. Well, a court might go, well, that's just procedural. And you'll see the courts are kind of struggling with, well, what's procedural? What's substantive? And so the judge here is saying, even if it's procedural, then the plaintiff has alleged more than just a bare procedural violation because a violation of the FDCPA risks real harm. And again, citing another case. And this is at Section E, so talking about deception, poses real or risk real harm to consumers' interests, including the right to be free from financial stress and invasions of privacy. And then here's another case from the Fifth Circuit, 2017. Plaintiff had concrete injury where the FDCPA violation exposed plaintiff to real risk of financial harm caused by an inaccurate credit rating. So the court's saying, I think there's enough here, but let me look and see, why was the FDCPA passed? Well, if you've seen our other videos talking about cases, you'll notice this is almost in all of them. It's to eliminate abusive debt collection practices by debt collectors. Why? To ensure those debt collectors who refrain from using abusive debt collection practices are not competitively disadvantaged, and to promote consistent state action. So it's really three things. Promote consistent state action, make it fair for those debt collectors that are following the rules. But number one, eliminate abusive debt collection practices. And then they cite to some cases here. So here's one out of the Second Circuit. The FDCPA was designed to protect against the abusive debt collection practice likely to disrupt a debtor or a consumer's life. And Section E prohibits inaccurate credit disclosures to protect against the risk of an inaccurate credit rating, financial harm that is concrete. And so the judge says, well, let me see what the plaintiff said here. Well, alleges inaccurate credit report violated the FDCPA, hurt his credit score and his credit reputation, and pled mental anguish. So the judge says, these are concrete injuries. Well, then Midland, they're not done. They keep arguing. So we have this interesting word, particularized injury. And they say he hasn't alleged that. And so we go, well, what's the test? We go back to Spokio, that's that U.S. Supreme Court case. It says it must affect the plaintiff in a personal and individual way. So here, this would be an example. If you said, I'm a member of the human race, and I want to sue Exxon for global warming. I'm just using that as an example. Whether you think, climate change, global warming, or don't think, it doesn't matter. But let's say you sue Exxon, and the Exxon says, well, you don't have standing because it hasn't affected you in a personal and individual way. And you say, well, I have an interest in the planet being healthy. Well, you'd be thrown out for that because anybody could bring that claim. And so it hasn't affected you in a personal and individual way. So think about what Midland is saying here. They're going, well, this hasn't affected you in a personal and individual way. Just on the surface of that, you go, that's the dumbest thing I've ever heard. It was his credit report. They're saying he owes the money. They're not saying the entire human race owes the money. They're saying he owes the money. How could that not be personal and individual? But this is the mentality of Midland. And really all these debt collectors is they make every possible attack they can if you dare to bring a suit against them. So you have to be prepared for this. And the court says, well, look, it is particularized because Midland's communication of false information to the credit reporting agents, that's Equifax, Experian, TransUnion, allegedly harmed his credit. And then they cite to some cases demonstrating inaccurate or incomplete reports regarding a debt to credit reporting agencies may harm one's credit. And then here's one from the Seventh Circuit Appellate Court. And noting material information provided to CRAs, that's the Consumer Reporting Agency, credit reporting, it's all the same thing, just different words. But that's a common initial or acronym for it, CRAs, will always have influence on the debtor, as this information will be used to determine debtor's credit score. So it's like, of course it affects them. And so Escobar sues to vindicate interest particular to him, his creditworthiness. And so it does affect him. And then, again, Midland, they're relentless if nothing else. Midland argues he's not alleged an actual or imminent injury because he only asserts an increased risk of harm. And the court says, no. He's alleged that he suffered actual harm. And then once he found out about it, he had mental anguish. So what Midland's saying is, well, you're just saying that maybe sometime, who knows when in the future, you might suffer something. So say there's a data breach and you say, nobody's stolen my identity or opened up a credit card in my name, but I'm worried that might happen. Well, you might need more than that, and data breaches are a little bit different, but just a general principle, the argument against you would be, well, that's just a worry about the future, but you don't have any actual harm. Here he's saying, no, you damaged my credit score. You damaged my credit reputation. And then when I figured out what you did, that caused me mental anguish. So I have actual damages now. And the court says on a motion to dismiss, I'm going to assume your factual allegations, these sort of general allegations, encompass specific ones necessary to support the claim. And Midland says, well, look, he's just claiming that there's imminent harm that's coming, which is a little odd, but that's their argument. And the judge says, no, he only has to allege actual or imminent, and he's alleged actual. So all of that is just Midland arguing you can't even open the doors to the courthouse. Now Midland says, okay, so you got into the court, but your claims under the FDCPA are no good. So now we're going to look at that. This first argument is one that they made probably, I don't know, 10, 12, 13 years ago. Midland would sue our clients. We'd beat Midland at trial. We would then sue Midland for false credit reporting, among other things. And they would say, well, you can only sue under the Fair Credit Reporting Act, not the FDCPA. And the Fair Credit Reporting Act sort of preempts or trumps the FDCPA, which is an absurd argument. And then they would say, but really you can't sue under the Fair Credit Reporting Act because you have no claim. You can't sue us. We're immune to suit. And then you can't sue us under state law because the Fair Credit Reporting Act, which you have no claim under, gets rid of all your state law claims. And so we point out to the judge, well, this is amazing. Midland's saying they have absolute immunity to do whatever they want. And the judge just kind of, like, what is this? And, rejected those arguments. So they're still making this argument, even though they stopped making it in Alabama where we sue them. I mean, it's been a decade since they've made that argument. But here they are. They just recycle these arguments whenever somebody sues them. So Midland says, Escobar is really trying to assert a claim under the Fair Credit Reporting Act. Well, why would you say that, Midland? Because reporting to credit bureaus is not a communication covered by the FDCPA. And remember in our video on definitions, that's 1692A, we talk about, what do these words mean? And it's important because Midland is saying, we didn't communicate to the credit bureaus. And then they say, well, even if the FDCPA applies, you haven't plausibly alleged a violation. And that's under Section E. And then the Section F, which is unfair, unconscionable, they say, well, that's just the same thing as your E claim. You don't have an E claim, so you don't have an F claim. And so first the court says, well, I'll grant you that one theory of the case is not pled correctly. And I don't want to spend much time on it because there's not much to it. But the consumer says, well, I had this inherent understanding that, I just assumed when I paid this that you guys wouldn't report this or you would report it as being paid. And the court says, well, here's a problem with that. Let me get through the highlighting here. Has not alleged any facts suggesting Midland or their law firm might have done to allow him to hold that belief. He's not alleged a single communication, contract term, or other action giving rise to plausible factual basis for his, quote, inherent understanding, or what the law firm or Midland did that led him to believe payment of debt would be reflected within the 6 or 7 weeks between August 21st and October 10. And so that one the judge rejects. And it's a clever argument, but there's no basis for it in my view. So here's what he looks at, though, which is whether Midland continued to voluntarily report the debt as still owed or failed to mark it as paid despite an affirmative duty to update its status. Okay, so there's a lot to unpack here, and there's some pretty important implications of this, so I want to go through all of this here. It's first, it conflates, again, you got to like the fancy language from Midland, conflates the duties of a furnisher under the FCRA are with those of a debt collector under the FDCPA. So remember, a furnisher under the Fair Credit Reporting Act is somebody who furnishes information to the credit bureau. So that's like your credit card company, your a medical group that's reporting you, a debt collector, anybody that provides or furnishes information to a credit bureau is a furnisher. And so the argument is your theory is really under the FCRA. And the court says, it's pretty simple, guys. The FCRA and FDCPA are not mutually exclusive causes of action. And then it looks at some cases here. So here's one out of New York. Misrepresentations made to a credit reporting agency fall within the plain language of the FDCPA. Nothing in the FCRA or the case law suggests the FCRA provides the exclusive remedy. So you can sue under both, and we often do that. We sue under the FCRA and the FDCPA. Here's another case out of Oregon. FCRA does not provide its exclusive remedy when a debt collector furnishes false information. Even if a furnisher cannot sue a furnisher under the FCRA, that would be because they did not do a dispute through the credit bureaus. You can send 100 disputes directly to the furnisher, the debt collector, but if you want an FCRA claim, you have to go through the credit bureaus to do the dispute. You can also dispute directly with the collector, but got to go through the credit bureaus. So even if a consumer cannot sue a furnisher of information under the FCRA, nothing forbids a consumer from suing a debt collector under the FDCPA. So gets rid of that kind of silly initial argument. Well, now they are attacking Section E. So let's see what that says. May not use any false, deceptive, or misleading representation or means in connection with the collection of any debt. And then we have a bunch of examples of that. So here's example number 2. So this would be 1692E2. The false representation, and then this is typically the one that we're talking about. The character, amount, or legal status of any debt. And then 8 would be communicating or threatening to communicate to any person credit information which is known or which should be known to be false, including the failure to communicate that a disputed debt is disputed. And then number 10, which is very similar to kind of the big section E here, the use of any false representation or deceptive means to collect or attempt to collect any debt or obtain information concerning the consumer. And so, again, silly arguments, but this is what Midland says. Because it reported the debt to the CRA, in other words, Equifax, Experian, TransUnion, and not to the plaintiff, Escobar, there is no, quote, communication within the scope of the FDCPA. So, again, why knowing the definitions is so key. The court says, but the FDCPA defines communication. So we don't have to guess what it means. We can just read the statute. The conveying of information regarding a debt directly or indirectly to who? Only to the consumer? No, to any person. Well, how? Through any medium. And then the judge says, this does not require that the conveying of information be to or from the person who incurred the debt. And so, again, looking at some case law here, I'll just highlight this for us. Communications regarding plaintiff's debt to a third party, including subsequent purchasers, transferees, or assignees, fall within the scope of the FDCPA. So, this would be an example if the debt collector knows that you don't owe the debt, but then they transfer it to another debt collector. Well, that would be communicating information to a third party. And if they don't tell that third party you don't owe the debt, well, then that's going to be a problem. Actually, if they tell the third party you don't owe the debt, then our question would be, why'd you sell it to them or transfer it to them in the first place? And then here's another case. Misrepresentations to credit reporting agencies regarding plaintiff's debt fall within FDCPA. Here's another one. Actually, I highlighted too far there. Allegations of defendants' negative reports to credit reporting agencies which result in derogatory information appearing on plaintiff's credit report sufficient to state a claim under 1692E8. And then the court says, look, the statute itself, E8, specifically applies to communications with any person, including but not limited to communications with credit reporting agencies. And so they go, okay, all right, we lost that one. Here's our next argument. It was not in connection with the collection of any debt. And so they cite a couple cases that dismissed the FDCPA claims because the alleged false misrepresentations were made in response to requests under the FCRA after plaintiffs disputed their debts. Now, I don't agree with these cases. I think they misunderstand the law here, but let's just go with how they're worded and think about the implications of this. So here's the situation. Communications were made to comply with the FCRA reporting requirements, namely the requirement that a debt collector respond to a notice that a debt is disputed by consumers. So you dispute to Equifax, Experian, TransUnion. If they do their job, they then reach out to the debt collector and say, hey, this consumer is disputing this. What do you say? Then the debt collector responds to that and says, get rid of it, update it, or verify. In other words, keep it the same. And so what a couple of courts there have said is that if the only reason that they update your credit report is that you sent a dispute through the credit bureaus under the FCRA, Fair Credit Reporting Act, then we're going to hold that that is not trying to collect a debt under the FDCPA. Now, in a sense, it doesn't really matter. I mean, I think that's incorrect analysis, but if it's false information, then you just sue them under the Fair Credit Reporting Act. Now, there are some advantages under the FDCPA. We prefer to sue them under both laws if we can. But that's the argument that Midland's making here is that when we communicate with the credit reporting agency, it's not actually communication here. And so the judge summarizes those two opinions. Thus, both courts found the communication were not made in connection with collection of any debt. Here's the problem for Midland. The parties agree there's no allegation that his debt was disputed through the credit bureaus, which would have imposed an FCRA reporting requirement on Midland. And instead, he's alleged Midland acting on its own initiative in reporting his debt to the CRAs, credit reporting agencies, did so in an attempt to collect the debt. Thus, it was voluntary and not in an attempt to comply with the FCRA. So the distinction between voluntary and required communication with consumer reporting agencies is significant. So the implication is that if you settle a case with the debt collector, a lawsuit, or even just settle a regular debt, you may want to think about whether you want to immediately dispute that or not. Because if you dispute it and they respond and update your report, then their argument will be, we did not violate the FDCPA, even though I think that's a just absolutely incorrect argument, but some judges buy that. And now you still sue them under the FCRA. So a different strategy would be wait a month or 6 weeks, let them voluntarily update. Most of these debt collectors update every single month. And then when they update it and it's inaccurate, well, now you've got the FDCPA, Fair Debt Collection Practices, and then you do a dispute through the credit bureaus. If it gets fixed, great. You still sue them because they had it on there for a month when they shouldn't have. But if they keep it on there, well, now you have the FDCPA and the FCRA. So it's a little bit more advanced strategy, but it's something to think about, particularly if your judges buy this argument that a debt collector can falsely report to a credit bureau as long as it's in response to a FCRA dispute, which again, I don't think much of that, but some judges buy that. Okay, so then here's the argument that Midland did not allege any activity, or they're saying the plaintiff did not allege any activity that amounts to debt collection, or that the trade line was, and trade line just means the account, was placed on credit report in attempt to collect a debt. That also fails. And to look at the complaint, it explicitly says you voluntarily continuously reported debt in an attempt to collect the credit card debt. And then this judge says, well, look at another judge in my own district. Reporting debts to credit reporting agencies is one of the most commonly used arrows in the debt collector's quiver. Now, you might recognize that quote from a previous video that we did where we went through a case decision. And it's absolutely true. This is one of the most powerful things here. So communications to credit bureaus effectuating changes to consumer's trade line or account do not merely inform a consumer of the status of his account, but may induce a debtor to pay to remove a cloud on his credit history. So here's a quote. That's a great quote. Debts are submitted to credit bureaus to impair or damage debtor's credit score so that in turn the debtor is induced to pay the debt. And that inducement of payment can amount to debt collection. And then here's the Seventh Circuit. It says, the FDCPA does not apply to every communication, but a communication made to induce a debtor to settle her debt will trigger the statute's protection. And so the conclusion is, it's plausibly been alleged that the reports to credit bureaus were made in an attempt to collect the debt. And again, another quote from a case. Reporting debt to credit reporting agencies, communication connection, and that subjects the debt collector to liability. And then the judge says, well, look, he said this was false. Well, why? Well, Midland reported credit bureaus the debt was still outstanding, knowing it's not. And we've talked about this, I don't know how many videos. The debt collector says, you owe $5,000 and pay us $3,000 and we're done. You pay him $3,000. How much do you owe? $0. It's nothing. They can't go, well, you technically still owe $2. No, I technically owe $0. If I owe $1 billion and somebody says, give me $1 and we're squared away, we're even after that. I give them the dollar. How much do I owe? Nothing. And debt collectors, we've been suing them on this for I can't tell you how many years. They just refuse to want to understand this. That when you settle the debt is gone, assuming you've made the payments. So back to the case here. The debt is still showed as owed when he viewed his trade line. And so for there to be a violation, we have to have false, deceptive, or misleading. And we test that by, and we've talked about this in other videos as well, the quote, least sophisticated consumer. Well, what does that mean? Here's a quote from another court. How the least sophisticated consumer, not the average, everyday, common consumer, understands the notice. And I like how the judge words this. The alleged misstatement, telling the CRAs that he owes money when Midland knew he did not, is on its face a false statement regardless of sophistication. You can be the most sophisticated, Chief Justice of the U.S. Supreme Court. It doesn't matter. It's still false because if they say you owe money when you don't owe money, that's false. There's nothing else to say about it. And then here's one, banning the use of any false representation of collector attempt to collect any debt. That's at subsection E10. And then the court says, least sophisticated consumer, actually any consumer, could easily be misled or inaccurately interpret the status of his debt when his trade line reflects an outstanding debt obligation nearly 2 months after making payments. And so that's a violation. And then Midland argues something called materiality. So let me just chat about this a moment, then we'll go down to a couple of these footnotes. Materiality is an argument that some judges are buying. I don't think that it's correct, but some judges are buying it. And the idea that, okay, I violated the FDCPA, but was it really material? Did it really matter? Well, the statute tells us that if you violate it, you broke the law. And so the argument is, the defendants have made this argument, some judges have been receptive to it, where the judges say, I think it was an innocent mistake. It's just kind of a technical thing. They didn't mean to do it. And it's a really, really minor thing. So I'm going to rule they didn't violate the law. Well, what they've done is misunderstood the law. If it was innocent and accidental, the debt collector has a defense. And remember, we had a video on this a couple days ago. The affirmative defense of bona fide error. And that says, hey, this was just an innocent mistake. I didn't mean to do it. I have procedures in place. It just slipped through the cracks somehow. Well, they can prove that. Well, what these judges have done is sort of flip this on its head and say to the consumer, you must prove this is a, quote, material violation. That's not what the statute says, but that's what some judges believe. So you have to deal with that. You have to know in your part of the country, do judges follow this materiality? And I'll say this, we don't bring cases that we think are, like I owe $500 and they put on my credit report, I owe $501. I'm not suing them for that, okay? Because I think a judge would look at that and say, what's the big deal? Even though technically that shouldn't be part of the analysis. So it needs to be something important, but just understand some judges have sort of made that a new requirement on you. So here's the discussion by the judge. Materiality requirement shields debt collectors from liability for, quote, mere technical falsehoods, while still holding them liable for communications and practices that could mislead a debtor as to the nature and legal status of the underlying debt, or could impede a consumer's ability to respond to or dispute collection. So that's kind of the idea here. And if we back up to these footnotes, the briefing by Midland is almost all on that first theory about his inherent understanding, which is out of the way. Remember, the judge rejected that. And so before we get back to the materiality, I do want to point out this first footnote. Midland argues it has no affirmative duty to update the trade line. And this particular judge agrees that Section 1692E does not impose an affirmative duty on debt collectors to update the status of each debt it has reported. And this really comes back from an Eighth Circuit case years ago. I don't know exactly how long ago it was, but about 10 years ago, I was asked to speak to a group of collectors and collection attorneys about credit reporting. And I referenced this case then, so it's at least 10 years old. And the idea was you dispute a debt, okay? Whether within that 30 days, the validation period, or it could be 5 years after the debt collector gets, you can dispute a debt at any time. Then that debt collector has to report your account as being disputed. But what if they just don't report after you dispute? They just leave it on there. So I'm recording this on August 14. So let's say the debt collector has one of my debts, July 1st was when they last updated it. I call them on July 20th and say, hey, I dispute this debt. And then in August, this month, they don't update it. They leave it on there. The last reported information is from July, but they don't update it July or August. They don't update it September, October, or anytime. Well, the Eighth Circuit said they have no obligation to go out there and affirmatively update the report. And a lot of courts have bought that. And I understand what they're saying. I don't necessarily agree with it because I think to leave something that is false out there is deceptive. But a lot of courts have bought this. So this is what we're talking about here in this footnote. So we agree with the Eighth Circuit that debt collector does not have an affirmative duty to notify CRAs, credit reporting agencies, that a consumer disputes the debt unless the debt collector knows of the dispute and elects to report it. And the judge here just points out that doesn't help you guys because you voluntarily did this. You weren't, nobody's saying you had to do it, but if you do report, you must report accurately. All right, so let's go back to materiality. Escobar alleges that continued to report his debt as unpaid even after he paid it, causing injury, and the misstatement of a debt obligation, especially the misstatement of the very existence of such obligation, no mere technical falsehood, it may mislead the least sophisticated consumer. And, well, how can that harm you? Well, application for a loan, housing, employment, and it may make the consumer pay out of fear. So we've had cases where our client pays the debt, and then nothing more is owed. And then they check their credit reports a few years later. It's still on there. They call the collector and say, hey, I'm trying to buy a house or a car. You got to get this off. And the collector says, tell you what, I'm being generous. It says $2,000 on your credit report. You pay me $1,000, then I'll take it off. Well, that's just blackmail. Okay, they know there's nothing owed, but they leave it on there. And we called this probably 15 years ago, parking an account. So they put false information on your credit report and then they just leave it there. And see, they don't update it because some judges will say, well, if they don't update it, they're not making a new violation. And they just leave it there. It's kind of like if I just pulled my car into your front yard and parked it and left. And you're like, what's this doing in my front yard? And maybe you're having, a party at your house, a wedding anniversary for your parents or whatever it might be. And all these people, family reunion, all these people are coming in. You're like, I don't want them to see John's, rusty car in my front yard. You say, John, get rid of the car. I go, tell you what, I'll get rid of it if you pay me $1,000. Well, see, that's crazy, but that's what these guys do. And so the court's recognizing you may be forced to pay out of fear or out of confusion. Well, it's on my credit report. I guess I still owe it. And so the court says, no, this is sufficient what's happened. This is really interesting under 1692F. I like what the judge has done here because so many judges will buy Midland's argument. The basis of Midland's argument is if the same facts are used to prove a 1692E, that's that deception claim, then they cannot also support a 1692F, which is unfair or unconscionable. And the court rejects that here. So Midland first argues that conduct does not fall under 1692F because he's already paid off the debt and it no longer existed. Okay, a really weird argument. But again, this is what Midland does and all these debt collectors. They say, well, wait a minute. The FDCPA governs collection of debts. You paid off the debt, so there is no debt. So we can report false stuff about this. And it's not trying to collect the debt because there is no debt. Again, just a stupid argument. But understand that's what these guys do. And court says, no, the collection of an invalid debt is an unfair practice. And says, although he paid his debt, he claims continued reporting has harmed his credit. And since reports to credit reporting agencies may constitute communication sent in connection with collection of the debt. And then here's the rest of the quote here. Alleged inaccurate reporting may constitute collection of invalid debt or the collection of an amount not permitted by law. That's what 1692F1 is talking about. And then no further allegations of unfair or unconscionable conduct are needed. Now let me go back to this footnote here. Again, just highlighting the importance of why we have to understand the definition. So Midland says he's already paid his debt, so there's no debt, so he's not a consumer. I disagree. A debt means, and this is straight from the definitions, an obligation or alleged obligation. So let me give you an example. We had a case involving identity theft. Another lawyer had it, got it ready for trial, and then said, hey, can you guys come in and try this case with me? So we got in right at the last moment. And it was identity theft. And so a debt collector was trying to collect identity theft account against our client. And they made this argument. They go, well, wait a minute. It wasn't you that took out the debt, so you're not the consumer. So yes, we were trying to collect against you, Joe Blow, but since it wasn't really your debt, you can't do anything about this under the FDCPA. And, our argument was, well, it's an alleged debt. We might not owe anything, but if you say we owe it, then it's a debt under the statute. And so that's what the court's doing here. So let's go back to this argument that some judges will accept. 1692F claim does not identify any different conduct than the 1692E claim. It fails. And the judge correctly points out these are not mutually exclusive. And the same conduct can violate both sections. And so again, very good analysis here. Each section targets a different type of misconduct. So what does E do? Well, it's practices take advantage of the naivety or lack of legal acumen, while 1692F is aimed at giving the debt collector an unfair advantage. Now, I'd also point out E is not just saying that you're gullible. E is just a false representation. You could be the most sophisticated person in the world, as this judge has pointed out. But here the judge is quoting from this Arias case. And then just summarizing, communicating false, deceptive, or misleading information regarding debt obligation may violate both E and F. Okay, so remember the three arguments from Midland. You cannot open the doors to the federal courthouse. That's that standing argument. Judge rejects that. Number two, you haven't alleged a violation of the FDCPA, Fair Debt Collection Practices. Judge rejects that. Number three is, Midland says, well, you don't have any actual damages. So Midland argues that failed to state a claim for actual damages beyond conclusory bare assertions. And the judge points out, but the FDCPA authorizes recovery for any actual damage. And damages are not an element of the claim. And this is important because particularly in the 11th Circuit, where I practice, so that's Alabama, Georgia, Florida, the lawyers on the other side, just almost any case that's filed, they file a motion to dismiss. And they'll talk to the judge about, well, there's no evidence. Well, we don't have evidence at the pleading stage. These are allegations. And they go, well, where's all the proof? Well, we first do the complaint, and then we take your deposition, and we get your person swearing under oath. That's where we get our proof from. And so they'll argue, well, you have to plead detailed allegations of actual damages and mental anguish. And the court here is saying, that's not an element. It's not a requirement. And remember from our other videos, some judges say there are 4 elements to an FDCPA. Some say 3. It's consumer, and some combine that consumer debt, and then debt collector, and then a violation. It's not damages. And so the judge points out, to state a claim for actual damages, plaintiff need only state he's seeking actual damages. That's all you have to do. As a general matter, damages are not an element of a cause of action. Rule 12b-6 motion to dismiss, therefore, cannot challenge the demand for relief. And then the judge goes on to say, well, look, you can recover actual damages, including mental anguish. Very important, because particularly for lawyers that are filing maybe their first few FDCPA cases, the lawyers will attack them and say, you cannot get mental anguish for FDCPA. Well, this is back in 1988 from the staff commentary. FDCPA damages include damages for personal humiliation, embarrassment, mental anguish, or emotional distress. Now, those are all kind of similar, just different ways of saying it. And then here's another one. Congress concern for emotional harms that violations of the FDCPA by their very nature may be expected to cause. If you remember our video on the very outset of the FDCPA, it says we find that this causes bankruptcies, invasions of personal privacy, breakup of marriages. So in other words, Congress knew from the beginning, if you have an abusive debt collector out there harassing you, it's going to cause you mental anguish. So the lawsuit says frustrated, agitated, mental anguish, learning, continued to represent debt was still owing when it was not, and that also hurt his credit reputation. And the court says whether to be able to prove these at trial, that's a question for another day. At this stage, the motion to dismiss stage, need only request relief as appropriate, which he has done, therefore deny. And so that gives you a really nice overview of the ways that debt collectors attack. Now, there's other arguments they make, but I just want you to see how relentless these guys are. When you sue them, they're going to throw everything they can at you. They're going to say, well, you can't open the doors to the courthouse. Well, you can under the FDCPA, but again, what I do, and this is definitely the minority view, I file stuff in state court. If it stays there, great. You know, I love being in state court. My background is personal injury. My law partner is personal injury. So that's where we've been, our whole careers is in state court doing wrongful death and car wreck cases and things like that. But if they take us to federal court, we're perfectly fine in federal court. But now the defendant can't make the argument that the doors of the courthouse will not open. It's like, hey, buddy, you opened them. You drug us in there. If you think we shouldn't be here, we're more than happy to go back to this local state judge. So that's an argument. then they'll attack every aspect of your claim. And this one, they didn't argue about being a debt collector, but that's a favorite one where they go, we're not even a debt collector, even though they clearly are. And then you can see they also attack on damages. So they're trying to first throw the whole case out and then say, well, if we can't do that, then we want to throw out your claims. Well, if they can't do that, then they say, well, now you have no damages. So just be expecting this. And, if you expect it, then it's not a problem. And, this is what they do. What's the old story about had the scorpion and the frog, and they're on the other side of a river, and the scorpion says, hey, Mr. Frog, let me ride on your back, and you swim us across the river. And the frog goes, come on, are you kidding me? I know you'll sting me, and I'll die. And the scorpion goes, Mr. Frog, what's wrong with your thinking here? If you're swimming us across the river and I sting you and you die, I'll die. It would be crazy for me to do that. Frog thought about it, so that's actually pretty good. So there's, get on my back, swimming across the river, get halfway out the river, boom! Scorpion stings the frog. As the frog's dying, he goes, what are you doing? You're going to die too. And the scorpion goes, that's what scorpions do. We sting frogs. So, when we go, why do debt collectors do this? Why do they make these arguments? It's just what they do. It's their nature. They can't help themselves. So we can get angry about it, which does us no good, or we can say, well, I know what they're going to do. Let me anticipate it. Let me make it as painful as possible for them when they do this. And then let me make sure that they end up having to pay for this. Because when Midland or Portfolio, whoever it is, they pay their lawyers all this money to file this stuff that has no legitimacy to it. And then your lawyer has to spend a bunch of time on it. Then at the end of the case, the court makes the debt collector pay your lawyer also. At some point, some accountant at these debt collectors says, wow, we could have settled that case for $10,000 when it was filed. Instead, we spent $80,000 on legal fees, and now we got to spend another $100,000 on the consumer's legal fees and pay the consumer $50,000. That's not very good math. So hopefully that will eventually take hold, but we've got to fight these guys to make that happen. So thanks for watching this video, and feel free to put any comments below. And if you like this and you haven't already, feel free to subscribe to our channel. And if I can help you in any way, it's alabamaconsumer.com, and my name is John Watts. Thanks a lot, guys. Bye-bye.